Consider the most stark contemporary illustration. Umar Khalid has been in custody in September 2020, nearly 6 years as of August 2026, under the Unlawful Activities Prevention Act. In the Delhi riots, larger conspiracy case arising from the February 2020 violence. Charges have still not been framed. The trial has not begun. In January 2026, a Supreme Court bench denied him and Sharjil Imam bail while granting relief to several co-accused, holding that Khaled and Imam stood on a qualitatively different footing because the prosecution material attributed to them central roles in planning and mobilization. A review petition against the judgment was dismissed on merits in April 2026. Fresh bail applications filed in the trial court in June 2026 again highlight the constitutional injury, prolonged incarceration without trial, in the face of the centre's own repeated observations that bail is the rule and jail is the exception, even under special statutes. When pre-trial detention stretches into half a decade under a law whose design invites abuse, the distinction between investigation and punishment collapses. Liberty becomes contingent on the convenience of the executive. Well, let me pause here and tell you a fundamental issue that is central to these issues that arise in court on a daily basis. We have a section 45 in the Act which says that a person is entitled to bail only when he can demonstrate to the court that he is not guilty and that he will not commit the offense again. Now, imagine a scenario. A gets arrested on day one and is produced before the magistrate. He does not know what the case against him is. He gets arrested and he goes to court and he asks for bail. Now, how does he tell the court that he is not guilty? He doesn't know what is against him. But the statute desires that he has to convince the court that he is not guilty. And that how will he demonstrate to the court that I will not commit the offense again? There's no way I can do it. Such a provision is upheld by the Supreme Court. Upheld. Day after day, year after year, individuals are arrested under this provision. And they never get bail. And what they do is when he's arrested, then the prosecution says that, look, we are investigating other people. So if we release him on bail, there'll be a problem. So till that investigation is over, he will not get bail. But that investigation is seldom over. It goes on for year after year after year after year. And people just rot in jail. That's the state of the law. And who's responsible for that? Not us. Parliament and the court. This is not an isolated failure. The same pattern of delayed justice and restrictive bail jurisprudence under UAPA and other special laws has affected other activists, students, and journalists. The prevention of money laundering has emerged as another powerful special law whose stringent provisions have been used against political opponents and businessmen. Section 45, as I mentioned, imposes the notorious twin conditions requiring the accused to prove that they are not guilty and that they are unlikely to commit any offense while on bail, effectively reversing the fundamental principle of criminal jurisprudence. Both the UAPA and the PMLA illustrate how special laws have been deployed to dilute the ordinary protections of personal liberty under Article 21 and to create a parallel system in which prolonged incarceration often precedes or even substitutes for a full trial. The trial against Umar Khaled has not even started, and 6 years have passed. And he's incarcerated because there are allegations against him. Now, allegations have to be proved in a court of law. And if the trial doesn't start, how will they be proved or disproved? And in the absence of that, why should anybody be in jail? Structural problems compound the crisis. The collegium system, once defended as an essential shield of judicial independence against executive interference, is itself under severe criticism from within the profession. Senior members of the bar, including those who once argued for its creation, I happen to be one of them, have publicly described it as having turned into a total disaster, marked by opacity, insufficient resistance to executive pressure, and at times complicity in the targeting of independent judges through transfers or delayed appointments. The executive's influence over the process of elevation, confirmation, and post-retirement assignments remains a persistent concern. When the political executive commands a decisive parliamentary majority and controls the investigative agencies, the incentives for judicial caution multiply. Selectively, an institutional response further damages credibility. Notices for impeachment proceedings against High Court judges have moved at markedly different speeds, depending on the nature of the allegations and the political context. One set of proceedings is expedited, another remains pending. The Supreme Court's own decision in early 2026 to ban a Class 8 devices textbook chapter that discussed judicial corruption, while blacklisting its authors from publicly funded work, sent a troubling signal about the institution's tolerance for public examination of its own vulnerabilities. Public faith, as I have said on earlier occasions, is eroding because the judiciary has, in critical moments, brought erosion upon itself.